Hello everyone, welcome to KU classes. In this video, I am going to explain you Justice KS Puttaswamy versus Union of India 2017. The case was related to right to privacy. Justice KS Puttaswamy versus Union of India 2017. It was a 9-judge constitutional bench and it was related to right to privacy. Now, background of the case. So what happened before 2017? It was unclear whether right to privacy is a fundamental right or not. And earlier, the judgment of MP Sharma and Khadak Singh, it was held that the right to privacy is not a fundamental right. Now, when Aadhar card scheme was introduced in the India, then people had some fear. They believed that the government was collecting fingerprints, iris scan, biometrics, and there was a possibility of surveillance, and there was no clear data protecting law. Then what happened? Justice KS Puttaswamy, a 91-year-old former Karnataka High Court judge, filed a PIL in 2012 saying Aadhar card violates the privacy. To settle the conflict among the old cases law, a 9-bench judge was constituted to decide is right to privacy a fundamental right under Article Constitution. Issue came before court whether the right to privacy is protected as fundamental right under Constitution or not, and whether privacy comes from Article 12, 19 and 21. The argument presented by petitioner side was that a person cannot live without dignity if the data is monitored, if their body is controlled and their choice are interrupted. Privacy is a part of Article 21, and that is why right to life is not mere existence of animal, and it should include autonomy, bodily integrity, personal freedom. On the other hand, the argument presented by government was that privacy is not a fundamental right. Even if privacy exists, it should be limited amount. Aadhar card is not violating of privacy, and over recognizing privacy may harm the state's capacity for government judgment. It was a unanimous judgment and all judges were agreed that the right to privacy is a fundamental right and overruled MP Sharma and Khadak Singh's judgment. Privacy should be protected under Article 21, 19 and 14. And Justice Chandrachud, he famously wrote a judgment where saying privacy is the constitutional core of human dignity. Now, the dimensions of privacy recognized by the court. First one was bodily privacy. Court held that protection from unwanted physical intrusion, example forced medical test, biometric without safeguards. Then comes informational privacy, which talks about control over one person's data and protects from surveillance, data collection, data misuse. Decisional autonomy, it means freedom to make personal choice, right to choose a partner, decision, food choices, personal habit, and state must protect citizen against the private data misuse. Another justice outlined 8 types of privacy, which includes body, mind, home, information, intimacy, communication. And lastly, Justice Sanjay Kishan recognized right to be forgotten. That's it for video. If you like my video, then please like and subscribe my channel. Bye.